Good morning. Richard Briansky on behalf of RFF Family Partnership Limited Partnership. May it please the Court. Burns & Levinson engaged in direct conflicting representation of itself against an existing client, RFF, without disclosure or consent. The result of Burns & Levinson's conflicting engagement should preclude the application of the attorney-client privilege related to those communications. There is no rule by which these communications would necessarily be precluded. Rather, what we're requesting of this Court is an exclusion to protect a client's interest who may have been or actually was harmed by these conflicting statements.
If a client sends a letter to the lawyer saying that I have a claim of malpractice against you, the lawyer can then consult counsel and consult his insurer, his malpractice insurer, can't he? Or can't it?
Well, they can do it, but the question is whether that would be privileged.
So you're suggesting that it is never privileged. It is that whenever an attorney receives a notice of claim of malpractice, any communications that the lawyer then has with his malpractice carrier's insurance is never privileged.
That would be our position, Your Honor. We would require disclosure and consent prior to those communications. And I think when you're dealing with those types of communications, how could you distinguish between the duty of the fiduciary duty which a lawyer owes to the client?
Well, I just want to make sure I really understand what you're saying. Automobile accident, not this case, an automobile accident. The attorney representing the plaintiff in the automobile accident receives a notice after the case is resolved, whatever, that there was malpractice. The attorney then contacts his insurance carrier and has conversations with counsel. Those are not privileged.
No, those would be privileged because it's no longer an existing client. We're making the distinction between an existing client who the attorney has current fiduciary duties, an obligation of full and candid disclosure, ethical obligations under 1.4 and 1.7.
So just to follow up, so even you couldn't call Professor Kaufman and hire him, and in this situation, Burns & Levinson has received a letter from you saying RFF is going to sue you, and you couldn't at that point communicate with either counsel for your insurer or separate counsel to discuss the issue?
You can. To me, the issue is whether you're going to apply the attorney-client privilege and how you reconcile the application with the attorney-client privilege with the attorney's fiduciary obligations and duty of candor and disclosure to an existing client. And I think it's reconciling those two in an applicable form that's clearly definable, which is what we're struggling with here and what a number of courts across other jurisdictions have struggled with.
So the only thing that could happen, really, what you're saying is that the lawyer who receives a notice like this from a client that there's a potential malpractice problem here really just has to cut off all communications from that moment forward with the client and say, we're done.
No, not necessarily, Your Honor.
How else could that lawyer who's being accused of malpractice or some other type of issue related to that ever protect himself or the firm from this kind of any conversation he would have with a lawyer seeking advice on how to handle it would be subject to disclosure on your view?
That's correct, Your Honor, but what we're suggesting is disclosure immediately to the client that there exists a conflict, a personal conflict, which the client deserves notice of.
All right, so the client gets notice that there's a conflict. What is the lawyer to do?
And an opportunity to waive the conflict, and I would direct the court.
The client doesn't waive the conflict.
Then I think there's no choice but to withdraw as counsel, assuming it's in compliance with the other ethical obligations.
Well, here there was a notice of claim of malpractice on March 2nd. And I think it was March 4th or 5th of 2011, I believe was the year. Upon receipt of that notice, the lawyer started talking to other lawyers in the firm. I mean, is there malpractice here? What's going on? And then within 5 days of the original notice, and after those consultations, the lawyers sent a notice to the client saying, we can't represent you anymore. I mean, you're saying that they terminated the relationship, or at least they sought to terminate the relationship at that point after doing some kind of a due diligence, an ethical due diligence to try to find out whether there was malpractice. I mean, what are they to do but what they did?
I would argue, Your Honor, that I would ask the court to look at that particular letter and find out whether that was the full and candid disclosure which was required under the ethical rules, whether they articulated to the client that there was an existing conflict of interest with regard to their current representation. And as a result of that conflict of interest, they were required to withdraw as counsel. To me,
Could I just clarify again, and maybe it's clear, but you make no distinction at all between the facts, circumstances, and other indicia of existence or not of a malpractice and any private communications, thoughts, viewpoints, opinions, expressions, exchange between the attorney who's accusing the malpractice or the attorneys and their counsel. No distinction or?
No distinction, Your Honor, because at the time there's an existing client, you need to reconcile that obligation of full disclosure.
So, and no distinction, and that covers the exchange always? There's no point at which there would be privilege if something happened or not happened, or it's always subject to disclosure according to your view?
Well, and I think I would refer the court to the in-house consulting on ethical issues issued by the ABA, and I think that makes it.
I actually just want to understand your position.
And I'm going to articulate it because it's consistent with the ABA's opinion, which was identified in our brief and also counsel's brief, and it makes a distinction between prophylactic discussions that you would have and discussions you would have which are directly related to preserving your personal interests. And that, to me, is the factual distinction that needs to be drawn, and that's why all communications with in-house counsel aren't per se discoverable. Rather, it's a fact-intensive review to determine what the actual substance of the communications would be. And in this particular case, those communications were directly adverse, and they were directly adverse to an existing client.
So there's the prophylactic and the directly adverse. When you say, oh, we've got this letter, I don't know what they're talking about. Do we have exposure here? What's going on? Are those prophylactic or are they already adverse?
I would say they were already adverse.
Get to the point when you're not at already adverse. When is it prophylactic?
That's simple, and that's when the lawyers and the client's intent or goals are aligned. For example, if a client said to a lawyer, I want to take this particular strategy, and the lawyer thought to himself, well, I can't take that particular strategy because it may implicate fraud or it may involve crime, it may limit I may be limited in executing the client's strategy. At that point, it's certainly both within the client's interest and within the lawyer's interest to consult in-house lawyers. That those communications would be privileged. The ABA also suggests that those discussions don't even necessarily need to be disclosed. But it's at a point where the lawyer and client's interests are directly adverse, like there was in this particular case with this particular meeting with Burns and Levinson, where they're not discussing anything which would advance the client's interest. Rather, they're discussing a defense as to the particular client's claims. And it's difficult to reconcile applying the attorney-client privilege in that particular circumstance with all of those lawyers who are sitting in the room have independent ethical obligations to that lawyer. The firm has obligations to the client. And there wasn't even disclosure that such a meeting took place. Think about the position it puts the client in. And in this particular case, I think you can see the manifest prejudice to the client who doesn't recognize that there is an existing conflict.
Well, the client the client knows that there was malpractice. Isn't this a standard malpractice claim? You look at the state of the title, and you have all the correspondence between the lawyer and the client as to what was expected by the representation. I want a first mortgage I want a first mortgage for this loan that I'm making. He didn't get it. It's a matter of record. Why do you need this information?
This particular information?
Yeah.
Because part of our claims, Your Honor, is that they should have fully disclosed to the client early on back in 2010 when the land court complaint was filed that they were potentially responsible and had a conflict of interest from that date when their failure to record a subordination agreement was at issue.
So wait, let me stop you right there. So you're saying, quite apart from your notice to them, right?
Correct.
The minute the land court complaint was filed by you?
Not by us. It was
Okay.
filed by a third party.
All right, sorry, you're right. Okay, the minute the land court complaint was filed, they should have said, we've got a conflict here, we can't represent you anymore. Is that what you're saying?
I'm saying they should have disclosed the conflict and identified it for the
All right.
client. And then at that point got the client's consent, because at that point there was a direct conflict of interest. These rules are supposed to be self-regulating.
Okay,
and
let
had
me
they-
ask you this, though. So, complaints filed. Mr. McClary says, oh, my goodness. I might say something else, but he says, oh, my goodness. I think there's an issue here. So he goes to talk to the ethical person. Now, you would say that conversation should be disclosed, right?
I would say that conversation should, well,
Why isn't that prophylactic?
no, I would say that conversation is prophylactic.
Well,
And
I
it's,
mean, that gets to Justice Duffley's question. Where do you start drawing lines here?
well, I think as soon as that there's an affirmative, the lines that have been drawn in the other jurisdictions, the clear lines have been when the client actually has given written notice or has articulated a claim for malpractice.
So by your standard then, the only way the attorney here could have preserved the privilege is to terminate the relationship with the client and then proceed to seek legal advice.
No, he would have disclosed to the client the potential conflict, sought a waiver or a waiver like he's required to under the ethical rules. And if that were the case, at least the client would be fully knowing waiving his rights and what exactly he's waiving. I mean, otherwise what you're justifying.
And the absence of waiver then, there'd be no privilege.
That's correct.
Now here, am I correct that you were retained by the title insurer to represent the client, to represent RFF?
That's correct.
So does that complicate things, because you're retained by the title insurer, because I gather the title insurer is going to be liable for the error and they therefore agree to pay for the legal services, but you're speaking on behalf of a client, and it turned out here that the client was not entirely at peace with the course of action that you were taking. How does that fit in here?
Well, two things. One, Your Honor, when I'm retained by the title company, they may pay my bills, but my ethical obligations run directly to the client. The client's the one who controls my moves. I can only do what the client tells me to do or limits me to do. I think what you're identifying is what I believe to be the particular prejudice that resulted from Burns and Levinson's failure to adequately disclose the potential conflict. My client, RFF, had a long-standing relationship, at least 3 years, with Burns and Levinson. It was a fiduciary relationship, one that he literally did trust these attorneys to act on his behalf. When he called them, they made specific representations. Don't worry, I don't know what you're doing. Everything's going to be okay. There was not the full disclosure that there was a potential conflict of interest, which they should have been. And as a result, you know, the record speaks for itself. But if you look at the series of correspondence sent by Burns Levinson, even the one on March 17th, which they're purporting to be a waiver, there's no articulation of any particular prejudice which may result from the continuing representation of Burns and Levinson. And yet their reaction on March 7th through that letter clearly identifies that there is an issue, that they've understood that there's an issue, one that justifies termination of the relationship. But then again, on the 17th, understanding that they felt compelled to terminate the relationship because there was an existing conflict of interest, they don't even articulate that to the client, nor do they advise the client to seek independent legal consultation, all of which is required under the rules.
So under the letter of, after they received the March 2nd letter, that's when Burns and Levinson should have made a disclosure to the client?
Absolutely.
But what? What would they have said?
That there's a potential conflict of interest with our ongoing representation.
But why wouldn't they have thought they had independent counsel, that the client had independent counsel? You. Well, you know, I mean,
That March-
representing, maybe paying, your bills being paid by somebody else, but you have the independent obligation to advise the client. You're the one who's written the letter saying that there's a malpractice problem. Why wouldn't Burns and Levinson be in a position to think the client has independent advice about this?
Well, the irony here, Your Honor, is that letter wasn't copied to us. That letter was sent directly to the client. And I don't know how you reconcile the two. If we were his independent counsel, at that point they should have sent us a copy of the letter, but they didn't. Conspicuously omitted at the bottom of that letter as a copy to us, while all the other letters fully informed us, recognizing our relationship.
Now, if I can speak practically for a moment, the judge below did not side with you on this issue, but ultimately said that they have an obligation to disclose because they didn't provide a privilege log, and is how does that fit in terms of this argument? I mean, I'm trying to. You're arguing this point, but ultimately you prevailed in the motion below.
No, well, we're seeking testimony here. Those were related to documents.
So it's a 30B6 deposition.
That's correct.
And the fact that it's been held, can you explain that?
Well, according to the judge's order, we could go ahead and hold the deposition, but not ask questions in the particular areas that he
So that's
had.
what you did?
That's exactly what I did, and I didn't think I was waiving any rights. I
No,
gave,
no, I'm not suggesting you are. I just
Yeah,
was
no.
just trying to figure out factually.
We were very specific as to follow the judge's order and his limitations related to those communications. But those communications, I think, are critical in our case because there's no other method for us to collect that information as to what Burns and Levinson knew at the time and why they didn't disclose this information to the client.
Well, that's not so, right? I mean, what Burns and Levinson knew at the time, it seems to me under the judge's decision, would be a fact. I mean, not Burns and Levinson collectively, but, you know, the particular lawyers who were involved, what they knew, you can ask them what they knew.
I did, and their memories were limited, extremely so, such that the only available information related to what Burns and Levinson knew at the time would have been through alternative sources. More so, they also need to explain why they continue to represent the client and collect money for defects that they knew that they were related to, which is part of our claim in the
Counsel,
underlying action.
your time is up.
Thank you.
May it please the Court. I am Thomas Peisch. I represent Burns and Levinson, Francis Perkins, and attorney Michael McClary. With me are my colleagues Aaron Higgins and Andrew Dennington. As the Court's questions have already indicated clearly, the issue presented here is a simple one, and that is, should this Court carve out a new and heretofore unrecognized exception to the attorney-client privilege so that conversations and communications which were clearly and undisputably for the purposes of getting legal advice somehow become admissible in evidence as an evidentiary matter?
Mr. Peisch, wouldn't this case be in a different posture if, plainly, Burns and Levinson, after getting that March letter saying that there's a malpractice issue here, felt the need to withdraw?
That is basically what happened, Your
Felt
Honor.
the need to withdraw, and thereafter had a conversation with the client. But wasn't that the point at which the problems really began?
It was that
And
point.
shouldn't there have been, something in writing clarifying the position of Burns and Levinson and what the client, so that the client was waiving any problems? I mean, wasn't that really the point at which this problem could have gone away?
Precisely that kind of exchange is what happened. The letter came in on March 2nd, Wednesday. The celebrated meeting that's the subject of these proceedings took place on Friday, March 4th. And as Judge Billings found, the next business day, which was the following Monday, Burns and Levinson sent a letter to the client with a copy to Mr. Briansky resigning from the engagement. That is what came.
Mr. Briansky says he didn't send a copy to him, I thought.
Mr. Briansky complains that we did not send him a copy of the March 17th letter, which is weeks after these events and, frankly, more or less irrelevant. We did send him a copy of the letter in which we resigned from the engagement. So there's no question at all but that the client knew that Burns and Levinson had resigned as a result of receiving the demand letter, which was exactly what was appropriate to do. Now, thereafter, there followed a series of events. I think Justice Spina's questions raised some of them, and we were convinced to come back into the engagement at the express request of the client.
But there was nothing, I guess, that March 17th letter, did that set out the terms of engagement going forward, or why it was Burns and Levinson felt comfortable going forward with this representation after it did not initially feel comfortable doing? I mean, you recognize that there was a problem. There was a problem, and so the question is, how was it addressed with the client? And it was that being addressed with the client, and however that was resolved, that was not communicated to Mr. Briansky's firm.
The March 17th letter, which again came a couple of weeks after the events that have formed the basis of the appeal, laid out by Mr. McClary, the real estate partner, that Mr. McClary wanted confirmation from Mr. Friedman that, in fact, Mr. Friedman had not directed Mr. Briansky's firm to file any malpractice claim. There was a reference to ongoing efforts to sell the property. Recall that the record establishes that Burns and Levinson was, at the time of this demand letter, which in the process of trying to sell the property that their client had acquired by way of foreclosure deed. So Mr. McClary's letter set forth a request for confirmation of that arrangement, which Mr. Friedman was delighted to give him.
That was the March 17th.
March 17th.
But it didn't set forth the possibility that because these senior liens existed, there was a malpractice.
It did not make a disclosure that there was a potential conflict of interest, but it did refer to the fact that the firm, that Burns and Levinson, had received a pointed, not only was it a demand letter, but it was a draft federal complaint, which ultimately did not get filed.
Well, in retrospect, would it have been better to have made that March 17th letter a fuller disclosure with regard and a more formal waiver?
For purposes of this proceeding, Justice Gantz, the answer to that is no. The issue before...
Why is it for purposes of this proceeding?
Because the Judge Billings's order really had nothing to do with the March 17th letter. What the 30b-6 deposition topics that are at issue in this case were very limited. What did Burns and Levinson do when they received the March 2nd letter, and how was the response that Mr. Davidson sent the following Tuesday, March 8th? Tell us what that was all about. There weren't even any deposition topics related to the March 17th letter. And
Is the focus of the deposition discovery the conversations that took place between March 2nd and March 7th?
yes, Your Honor.
And no others?
No others.
Is it your position that even if there were a Rule 1.7 violation, which you of course say there was not, that is not relevant to the issue of whether there is a privilege?
If there was a 1.7 violation with regard to the March 17th communication, our position is that that has no relevance to the issue before the court today. The issue before the court today is whether or not the lawyers who gathered in a conference room to discuss the appropriate response to this demand letter, whether or not those conversations are privileged. Everybody who has weighed in on this issue agrees that it is desirable for lawyers, especially in this day and age, to have readily available to them a mechanism where they can receive ethical advice and claims management advice easily. And, yes, Your Honor.
I have two questions. One is, you say everybody, but I gather from Judge Billings' decision and also the brief by Mr. Briansky that if you were to count noses, the majority of cases in this country go the other way. Is that right?
In terms of raw numbers, probably, although the gap is narrowing. And as we point out in our brief, the best and most well thought out consideration of all aspects of this issue are set forth in the Tattletale Alarm and the Garvey cases, which considered a lot of things that are totally left out of RFF's brief, including the major policy questions. Those two cases, which Judge Billings found convinced him on the basis of this record, we say should convince this court as well.
Okay. My second question is, you say the only issues before this court are really, and I'm just going to use dates for ease of reference, you know, it sort of ends on March 7th. March 17th is beyond the scope, right?
Yes.
Well, Mr. Briansky says that's, at least that's what I heard him arguing today, is that's sort of the heart of the malpractice case. So I guess I'm wondering, isn't it sort of an issue here?
Mr. Briansky may or may not have a malpractice case going all the way back to when the first challenge to the title was made. He may or may not have a malpractice case arising out of the March 17th letter and who was copied on it and what it said. But what he does not have is a right to interrogate these lawyers as to what they discussed on March 4th when they convened in a conference room at Burns and Levinson to decide what to do about this difficult situation. Now, remember, this did not happen in a vacuum, obviously. The efforts to sell the property were ongoing. The foreclosure had taken place, And in the middle of this work, the lawyers are faced with really a serious dilemma. What do we do? Well, the first thing any court would want lawyers to do would be to consult with somebody who has a background and who's been designated by the firm a stranger to the client, which Mr. Rosenblatt was in this case, to get some ethical advice. And that is exactly what happened here. Judge Billings made a clear finding that that was the purpose of the meeting. There's nothing in the record to the contrary. Mr. Briansky's brief says the purpose of the meeting was to construct a defense. He doesn't cite anything to the appendix because there isn't any support for that proposition.
So you're saying that if there were other conversations between Burns and Levinson lawyers over the period of time that the representation continued of Mr. Friedman about any potential malpractice issues or angles or anything like that, that is not the subject of this appeal at all?
That is, if they didn't happen between the receipt of the demand letter on March 2nd and the sending of Mr. Davidson's response on March 8th, they are not part of the record in this case. And they may or may not be independent issue in the case at some later point. I don't think they will be, but that's certainly certainly a possibility.
I guess I hear what you're saying, but it's a bit troubling because I take it what you're saying is even if this issue is resolved in the way for which you are arguing today, there may be a different answer to March 17th going forward. Is that what you're saying?
It's hard for me to, based on the way discovery has gone so far, it's hard for me to conceive that that would be the case, but I certainly couldn't rule it out.
So we're back
That
here
doesn't,
again?
but that doesn't, the issues that were before Judge Billings were very narrow, and as you well know, there was a lot about Judge Billings' opinion that we didn't like, but he accepted the holdings of those two cases, the Tattletale case and the Garby case that I mentioned. He canvassed the previous authority, most of which is, frankly, predates the advent of law firms having in-house ethics counsel, and in a very well-reasoned, articulate opinion, set forth why these conversations must be privileged if it is desirable to have lawyers freely exchange information for purposes of getting and receiving legal advice when situations like this come up. Now, just think about, in terms of practical consequences, what would happen if RFF's exception to the attorney-client privilege is adopted by this court? Ms. Higgins is the ethics partner in my law firm. If someone comes to her with an ethics issue, the first thing that Ms. Higgins is going to say, wait a minute, don't tell me anything. Does the client know you're here? Does the client consent to your being here? Have you gotten the client's informed consent? Have you suggested that the client get outside legal advice? Now that, I would suggest to you, is absurd, unworkable, and flies in the face, at the very least, of Rule 5.1, which requires partners in a law firm to make sure that everybody who works in the law firm complies with the rules of professional conduct.
Mr. Peisch, I'm going to ask you just to change focus slightly. There's sort of a mushing here between the fiduciary exception and the current client exception. Could you address the current client exception and explain why you think Burns and Levin is compliant with the current client exception?
Well, the current client exception has really not been solidly recognized here, but giving the benefit of the doubt on that issue, at the time of these consultations, there is no material adversity of interest between the client and the lawyer. As a matter of fact, the interests of both are the same. It's in the client's interest for the lawyer to be able to resort to experienced counsel to get ethics advice, and it's also in the lawyer's interest for that mechanism to exist. So that's where we would resolve any question about the current client exception. Now, Mr. Briansky's brief kind of fudges the current client exception with the fiduciary duty exception, and as we point out, they're actually two separate doctrines.
Well, how did what happened here dovetail, if you will, what the requirements of the current client exception impose upon you.
They dovetail because when the demand comes in on Wednesday or Tuesday, the lawyers get together on Friday, have a consultation with Mr. Rosenblatt, who is specially designated and, as I indicated, a stranger to the client. And as a result of that conversation, as Judge Billings found, the next business day, Monday, Burns and Levinson withdraws from the engagement with a copy to Mr. Briansky, the lawyer hired by the title insurer. That is exactly the kind of action that the rules of professional conduct require and that this court should expect of competent ethical lawyers like those at Burns and Levinson.
Just to be clear, are you challenging the judge's ruling with regard to the production of the documents?
We are not.
Okay,
We
so
are
the-
not.
so
And
the
we produced them. They're mainly, should we go to conference room 11 or conference room 12? But we produced them. We're big boys. He didn't appreciate the fact that we didn't file a privilege log, and we took our medicine.
So the only issue essentially before us is what happens when Mr. Briansky renews that deposition.
Yes, and he's already taken everyone's deposition, and as I remember it, reserved his rights to haul everybody back if this court agrees with him that there should be this new exception. I would ask you all to consider the policy implications if this exception to the hearsay rule is adopted by this court and affirm Judge Billings' blow.
I
Thank you.
have to say what's troubling me, and I'm sorry, I just want to ask one more question, is that if we, as you presented, the issue before us is only a teeny piece of a larger issue. Is that correct?
That is so, Justice Botsford, yes.
So,
But the issues are,
being unanswered, the much larger, I mean, you know, again, to use this case, the March 17th going forward, which sort of goes to Justice Duffley's question, right?
well, I will say this, that Mr. Briansky and RFF are everything, if not resourceful. They have yet to hone in on the March 17th letter as a viable claim in the case, and they have yet to hone in on it as something as to which they want to conduct discovery. If and when they do that, we'll deal with it.
Thank you, sir.
Thank you very much.